This amendment was created to ensure that when you've gone through the criminal justice system in America and now it's time for sentencing, that a judge cannot sentence you to any cruel or unusual punishment. If you get a DUI, I don't sentence you to be locked up out in the cold for 10 days on a flagpole or tied to a pile of ants. And we don't do things that are cruel. We don't put people on the rack. We don't do cruel punishments like they do in North Korea, where they put you in a cage with dogs and the dogs chew you to death. This was to prevent cruel and unusual punishments, or punishments that didn't fit the crime. Excessive prison terms for lighter crimes, or excessive prison terms for white-collar crimes that weren't violent. And also to keep people who were arrested and placed in jail with reasonable amounts of bail or bond money to secure their release so they can prepare their defense outside of jail and go into the court system prepared. And this is basically to protect everybody. It's the basis of our system is that you're not guilty until you've been proven guilty in a court of law. You're innocent until that time, and you need to be treated fairly. And then after you're found guilty, that you're sentenced accordingly. So, a very important amendment. Every day at 1 o'clock, if you come to the courthouse, you can watch me apply this amendment when I see prisoners from the jail. There's usually 5 or more prisoners, and one of the very first things I have to do is determine whether to release them from jail, if I'm going to hold them on bail, how much. It has to be reasonable. It has to be in line with the law and what the fines are allowed to be and what a possible jail sentence is for them. I have to decide whether they have ties to the community, whether they have to work, if they're a flight risk. And basically, the Eighth Amendment is telling me how I'm supposed to do that. That affects my job every single day. I have to give reasonable bail. Secondly, when I sentence people to jail for crimes, I have to take what the maximum penalty is and the circumstances, and I have to apply that properly. If somebody gets a first DUI, it was a fluke thing and they're never going to do it again, they don't have a drinking problem, I'm probably going to give them the minimum sentence, where I'm going to give them 24 hours in jail, suspend the rest of the 6 months, give them the minimum fine. I'm going to let them pay on time payments. We're going to send them to alcohol school, known as the ACT class or the Pride for Life, and they're going to get a very standard and reasonable sentence that matches the crime. I'm not going to stick them away for a year in jail, take their driver's license away for 3 years, fine them thousands and thousands of dollars they can't pay, and we're not going to do anything that's cruel and unusual. So this affects people every day, whether they know it or not. If it hadn't been created, we would still be stoning people to death, or putting people on the rack, or putting them in the stocks out in front of the public square, or we would be punishing people with lengthy, harsh prison sentences in little tiny cells in caves, basically. And we would be holding people against their will or against any sort of reasonableness in jail until they have their trial on very high bonds or with very, very tight restrictions that are not reasonable. You wouldn't have the right to defend yourself and prepare your case outside of court or outside of jail, and be able to do that. We have other countries like North Korea that just at a whim they decide to punish or kill you, and they hold you without bail for a long, long time before you're even told what you're charged with. There's no way to get out of jail in some countries. There's no bail, and if there is bail, it's not reasonable, and the punishments for crimes are cruel. They're unusually strict and not humane. I think the public perceives it just the way it is, and I think it's applied properly. You will see times where there are sentences and bonds and things given that are too light. We have the example of the district judge in Billings who gave the incredibly light sentence to the man who basically had intercourse with a 14-year-old girl and had a relationship with her and was convicted of that. The public did not like the sentence he gave. It was too light. It was inappropriate. Secondly, you'll see the public fight against the death penalty. They perceive it as being cruel and unusual punishment and against the Eighth Amendment. And quite frankly, some of the punishments in the past and some that are now used, the electric chair, the gas chamber, hanging, some of those seem to me to be cruel and unusual, to keep people and then basically kill them in that manner. I don't know if there is a humane way to kill humans or the state should put people to death. And so there's lots of debate about that and about lengthy sentences for drug users. Drug crimes are the forefront. About 85% of the people in the prison, in Montana's prison, are there for drug or alcohol crimes. And a lot of the public perceives the sentences they get, the minimum mandatory sentences, especially in the federal system, as being too harsh, unusually cruel or long. And so I think there's a lot of debate individually about different cases, and the public does bring this up occasionally in this spot in the press. Care because we want to make sure that people that are arrested and charged with crimes in the United States are treated fairly. From the very moment that they're arrested, they have all the rights that the Constitution implies, that they have the right to be admitted to bail, that bail be fair, that they have the right to counsel, they have the right to represent themselves in a jury trial or a judge trial, they have a right to a trial with a jury of their peers from the streets, other citizens to judge them. And then if they're found guilty, they have the right to have a sentence that's commensurate with the crime, that is fair.